Hello, my name is Crystal Dahl, and I am the Online Communications Specialist here at Meritas. I would like to welcome and thank each of you for joining us on today's webinar, Interest Rate Hedging for Commercial Real Estate Finance Transactions. Before we get started, I want to quickly go over a few housekeeping items. Meritas now offers the ability to listen to our webinars through your computer speakers. If at any time you have any difficulty hearing the presentation, you may call into the associated telephone line instead. All phone lines will be muted. If you experience any technical difficulties, please press *0 at any time to connect with a support technician. Since you will be muted, if you have a question, please ask via the chat feature found on the left-hand side of your screen. Mark plans to answer most questions at the end of the presentation. Lastly, in the next few days, I will distribute a copy of the presentation, a recording of the webinar, as well as Mark's contact details. Our presenter today, Mark Heimendinger, comes from the Meritas member firm in Orlando, Florida, Lown, Strosdick, Doster, Cantor, and Reed. Mark has worked on a broad range of financing structures and instruments with a particular focus on real estate finance and structured finance. He has represented lenders, borrowers, and underwriters on a variety of transactions and asset classes, including term and revolving credit facilities, public and private securitization transactions, including CMBS, mezzanine finance, real estate and equipment financing, currency and interest rate cap and swap transactions, underwriting agreements, intercreditor agreements, joint ventures, and jurisdiction-specific non-recourse structures. With regard to his derivatives practice, his focus is on hedging arrangements to support secured financing in the form of interest rate and currency swaps and cap agreements. With that, Mark, are you ready to get started?
I am. Thank you, Crystal.
You're welcome. The floor is yours.
All right. Hello all. Thank you for joining us. Today we're focused on interest rate hedging for real estate finance transactions. A lot of what we're going to cover will be applicable to other transactions that are not just real estate transactions. Anything from revolving credit facilities, equipment financing, etc. But I try to focus this primarily on real estate finance because that's what I focus a good chunk of my practice on. When I've discussed this area in the past, particularly in person, I've always asked how many attendees are comfortable with ISDA documentation in Dodd-Frank. I'm going to assume here that most of you are not, although if I'm wrong in that, please feel free to interject by messaging me. And if I get enough of those, I can sort of move ahead past the basics. Overall, I plan to cover 3 areas. 1, background and context, including some basic terms. And that's the area I can skip over if enough of you note and tell me to move ahead. 2, I'll go over ISDA documentation architecture itself. Most of the attendees here are lawyers, so it's important we cover this. And if you're not, I think it's helpful anyway. And finally, the relevant regulations. I'm going to primarily focus on Dodd-Frank when it comes to regulations because that is the regime that covers us here in the U.S. But you should also be aware of EMIR, the European Market Infrastructure Regulation, which is the EU equivalent, though we will only touch on that. It's also important to note this final topic will likely be impacted by last Tuesday's election of Donald Trump. And while it's speculative at this point, I'm going to attempt to provide some commentary on where we might be headed when I touch on regulations. Suffice it to say for now that Trump's point person, Paul Atkins, who was commissioner of the SEC and served from 2002 to 2008, has been a heavy critic of burdensome regulation. So, to start on some context, ISDA itself is the International Swaps and Derivatives Association. It was established in 1985 and, among other things, has worked to standardize derivatives documentation and to seek to make sure that the provisions, including netting and collateral provisions, are enforceable in various jurisdictions. Currently, it has around 850 members from 67 different countries. The original master agreement and documents were created in 1985, and they've gone through several iterations over the years. ISDA covers several asset classes that they divide between interest rate derivatives, or IRD, credit default swaps, or CDS, equity, foreign exchange or FX, energy, structured products, and other. And I've posted here some interesting information on the size of the derivatives market. But what we're talking today are interest rate derivatives, and while they account for a large portion of the market, IRDs with non-financial end users are but a small fraction of that overall market. Another interesting point to note, particularly in light of Dodd-Frank, which was enacted in July 2010, the market has fractured, and apparently somewhat from Dodd-Frank. The U.S. was the first to implement legislation like this, and while implementation has been progressing since, some would say that the U.S. may have moved a little rapidly and could have better coordinated with other jurisdictions. The U.S. swap execution facility rules were implemented in October 2013. Those rules required that all electronic trading venues providing access to U.S. persons register with the CFTC as SEFs. Interestingly, according to a May 2016 ISDA research note, 91.2% of all cleared Euro IRS activity in the European interdealer market was between European counterparties as of December 2015. 91.2%. By way of comparison, in September 2013, immediately before the U.S. swap execution facility rules, the same figure stood at 71.7%. So it has had an impact. Dodd-Frank has had an impact. Moving on. Let's see. I want to go through a few of the key definitions to provide some guidance. One, simply a derivative. That's an instrument or contract that derives its value from an underlying or reference asset. And more precisely, a derivative will derive its value from changes in the value in the reference asset. Derivatives include swaps, forwards, futures, and options. And note that Dodd-Frank somewhat unhelpfully uses the term swap when it really means derivative. The swap is a type of derivative. Definition of notional amount. The notional amount on a derivative instrument is the nominal or face value that is used to calculate the interest payments made on that instrument. The notional amount itself is not paid or exchanged, and that's why it's notional and not principal. And I think that's probably enough on that, unless anybody has any basic questions or confusions at this point. Okay. Going on, I also want to focus on the fact that most of what we're talking about today are single currency transactions done in the U.S. market. So we're not talking currency swaps, and we're talking primarily U.S. regulation again. That said, the documentation and provisions you're going to encounter will cover both currency and interest rate swaps. That's often the case if a parent company, for example, is investing overseas. Okay, so a little more context. Looking at swaps versus caps, and a little bit of information on the difference. Swap is an exchange of cash flows. It's an exchange of fixed rate cash flows, at least in interest rate space. It's an exchange of fixed rate cash flows for floating rate cash flows based on the notional amount. The notional amount may be fixed, but it may also change over time, such as with an amortizing loan. If you're familiar with forward contracts, it's somewhat helpful to think of a swap generally in terms of a series of forward contracts. And I'm not going to go into pricing because it's obviously out of my area of practice, but I will say two things that are worth considering. One, the value or price of a fairly priced swap at inception between two willing parties, not a provider and a purchaser, for example, would be zero. And two, the value of a floating rate bond at closing will equal its par value. The value then of any swap in the future will derive from changes in interest rates and to some degree credit considerations. In contrast, an interest rate cap is a type of interest rate derivative in which the buyer may receive payments at the end of each calculation period in which the interest rate exceeds an agreed strike price. It may be conceptually helpful to think of a cap as insurance against interest rate spikes, but that said, legally, they're explicitly not insurance contracts. Party B, or your borrower, in the transaction or in the overall transaction will pay for the cap up front, and in exchange for that payment, which largely ends the obligation of Party B will be covered for interest rate hikes above a strike price. So rather than swapping the total cash flows, the counterparty is simply receiving the cash flow, if any, above a certain LIBOR rate. And I'll note here that when you're negotiating a cap, it's very important to minimize the possibility that the cap may be terminated by the cap provider for the obvious reason that you've paid for it up front. Okay, I'm going to move on to our next section, talking about the documents themselves. There's 7 basic documents that you're going to run across quite often. And just to sort of run through what those are, that's the master agreement, schedule, and confirmation will form your basic 3 documents. There's something also called a long form confirmation you may come across, which incorporates the schedule and confirmation in one document and then incorporates the master agreement by reference. And any transaction will have those 3 or at least the long form confirmation. In addition to those 3, you may come across credit support documentation or guarantees. The 2006 ISDA definitions. Now, if you look at the master agreement, the back of any master agreement, whether it's the 92 or the 2002, you'll note that all the definitions that are needed for the master agreement are there directly in the master agreement. The 2006 definitions were created for interest rate and currency transactions or transactions that have those features. And they've added these definitions for negotiation of other terms, such as day count fractions, currencies, rate options, etc. So they may or may not be applicable to any transaction. It's also important to note, when you look at the 2006 definitions, if you incorporate them without stating otherwise, all amendments and supplements up to that date will also be incorporated into your agreement. And then, of course, all amendments and supplements after that date will not be incorporated, unless it says otherwise. There's also something called ISDA protocols. These allow ISDA members to sign up for various overarching amendments and changes to their documentation so that they don't have to amend every transaction. The first one of these was for the European Market Unity Protocol, which happened in '98. There's also 2 Dodd-Frank protocols, one from 2012, one from 2013. It's important to note that on those protocols, the 2013 is not an amendment of the 2012, they're separate protocols. And then there was also a 2002 Master Agreement Protocol when the Master Agreement was created. That's now closed, although I do see it incorporated by reference and documentation from time to time. I don't see why that's done, to be honest with you, because you could just simply use the 2002 Master Agreement. But it does come up. All right. When it comes to reviewing the documentation, I think we're all very familiar with third-party swap providers and advisors such as Chatham. They do a fantastic job of bidding out, of creating a package for the purchaser and then bidding them out. I think it's important, though, as counsel, you do not get complacent and that you stay part of that process. The reason for that is the company's focused on creating the bid package and then bidding it out. They may not know what's going on with the underlying loan documentation, and you may be on iteration 3, 4, or 5 of the loan or credit agreement, and they may still be using version 1, and things change. And so you need to make sure that you're in constant communication with them and keeping them updated and also reviewing the bid package. Because once it goes out for bid, it's done. And you need to make sure that that bid package is consistent with the underlying loan transaction. That's particularly important if you have downgrade provisions in the loan agreement. You want to make sure that any obligation to replace the swap provider or replace the cap is in turn placed on the swap provider or the cap provider. The obligation is obviously still going to sit with the borrower, but it's much nicer if the borrower can turn around and enforce its obligations against the cap or swap provider. It's important that the ratings are correct and any collateral provisions are correct and consistent. It's also helpful to check the date, the accrual periods, the LIBOR definition, etc. Okay. So let's talk about the master agreement itself. There we go. There's 2 master agreements currently in place. To provide a little bit of history here, in '85, when ISDA was formed, they created an '85 version. They created another version in '86. In '87, they came up with the idea that we'd have different documents to cover, so you'd have a master and a schedule, etc. And then finally, they came up with the '92 master over time. In '98, we had the Russian currency crisis, and the documentation was tried. And while it did survive the Peregrine Investment Holdings case, ISDA thought it best to come up with a 2002 master that addressed some of the problems that arose there. So I will say that there's still many financial institutions that use the '92 master agreement, but not all of them. I think your larger financial institutions tend to use the 2002, and I say tend because there are several very large financial institutions that prefer the '92. So what is different? What changed? The primary difference was determination of damages or closeout amount. In '92, that master agreement uses either a market quotation or loss definitions. In 2002, they came up with the closeout amount, which in some respects combines both market quotation and loss, and in a lot of respects is very fuzzy. Just to give you some background, market quotation is an amount that's determined based on at least 3 reference market makers. So if you're determining your termination amount, the non-defaulting party or the non-affected party will go out and get at least 3 references from market makers. If there's only 3, then they'll take the middle point and throw out the highest and lowest. If there's more than that, they'll take the mean of the middle ones after again throwing out the highest and lowest quote. If there's fewer than 3 quotations, then you can't use market quotation. By contrast, loss focuses on the amount that the losing party reasonably determines in good faith to be its total losses and costs, including any loss of a bargain, cost of funding, but it does not include legal fees or out-of-pocket expenses. And all of this is determined as of the early termination date, or if not reasonably practical, as of the earliest date thereafter that is reasonably practical. And again, it goes on to say that a party may but need not determine its loss by reference to quotations. Well, during the Lehman bankruptcy, we finally had some real litigation come out of this in the United States. There's actually very little litigation on these calculations over time. In 2015, the U.S. Bankruptcy Court for the Southern District of New York, long story short, enforced the loss provision against Lehman and said that because loss had been chosen and because Intel chose to use loss, which they were rightfully able to do under their master, that they were not required to use market quotation at all. By contrast, the 2002 master uses closeout amount. And I'm going to read a little bit of this to you, and I apologize for that, but I think it's the easiest way to sort of go through the difference. Closeout amount is determined by a party or its agent acting in good faith and using commercially reasonable procedures in order to produce a commercially reasonable result. In determining the closeout amount, a party may consider any relevant information. And it goes on to say that you can use market quotations. You can use relevant market data that you get off from reporting companies. You can use your internal data if it's similar to the quotations or it's similar to the relevant market data, and you're using that information to quote out swaps to other parties. And it goes on to emphasize that the determining party will consider such information unless it reasonably believes in good faith that such quotations or relevant market data are not readily available or will produce a result that is not commercially reasonable. So I'm often asked, hey, how do we determine our closeout amount, or how do we determine this if we want to terminate the swap? And the reality is you really have to go to your counterparty and discuss it with them, because you've got to find out the procedures that they're using. You can come up with your market quotations that you think are reasonable, and you can discuss it with your counterparty. But if you're going to be the one terminating the swap, then they're the affected party, and they have the right to make this determination. So you really have to go discuss it with them. It's not as easy as just running the calculation. In addition to those provisions, and I know that doesn't provide a lot of help, but the emphasis really is on you need to have a conversation. In addition to that, in addition to closeout amount, market quotation, loss, the 2002 Master Agreement made a couple of other changes. There's a new set-off provision in Section 6F that allows a non-defaulting party or non-affected party to, without notice, set off amounts against the other party, whether or not under the same master agreement, and whether matured or unmatured, and regardless of currency, place of payment, or place of booking. It's a very broad rights of set-off. In addition, there's a force majeure termination event in 5B2. There's several procedures that they have to go from 3 to 8 days. They may have to book the swap and pay it out of another office if that's available, but eventually a termination amount would have to be paid. There's also consolidated interest and compensation provisions in new Section 9 of the 2002. And then several provisions were amended, shortening grace periods associated with some of the events of default in Section 5. So there are a variety of changes. Let's move on to the next slide. Okay. Now on this slide I say 2002 Master Agreement, and that's actually a mistake of mine. That's a typo. That should just come out. It just should be the Master Agreement. And I want to sort of step back for a second and think about what a Master Agreement is. And I'm certainly not the first one, and I won't be the last one to say this, but it's best to think of a Master Agreement as a bilateral credit agreement. I'll go through some of the provisions later, but suffice it to say that it looks like a very brief standard LSTA credit agreement in a lot of ways. The obligation of each party to make payments to the other party is dependent on its counterparty to have no event of default or potential event of default, and both parties may owe a net amount to the other, both at the time of each payment. So all payments made on the same day in the same currency under the same transaction will be netted against each other. All that means is that at the end of the day, only one party will be paying the other on any payment date. Whichever one owes more, they'll pay the net amount. And then that also applies on payments and early termination. So you'll have closeout netting, and then it makes clear that everything is a pre-estimate of loss and not a penalty. It's very similar to any credit agreement that you'll come across, except that rather than having a single borrower and a single lender, it's bilateral. Both are essentially debtors to the other. In addition to that, there's an indemnity by any defaulting party to the other party. So again, even if you're the borrower under the loan agreement, under the master agreement, you're being indemnified and you're indemnifying. And then there's no transfers by either party unless this is changed in the schedule. The general rule is you can't transfer. And then again, as a bilateral credit agreement, both parties may enforce remedies under Section 5. So then I've set out on the next slide, the next two slides, just the table of contents of the master agreement. And I do this solely to give you an idea of what I mean when I say it looks a lot like a brief credit agreement. You've got your basic interpretation, which reference the definitions in the back. Your basic obligations are in Section 2, very similar to any LSTA credit agreement. Representations in 3, covenants, agreements in 4, et cetera, as you go down the line. So again, the structure is very similar to any other credit agreement. And I'm not going to read all those to you, but that should give you some idea. So we'll go in a little bit more detail on the schedule here. The schedule's broken up into 4 basic parts. And this purpose of the schedule is to amend the master agreement and also make certain elections under the master agreement. So you have a master agreement which does not change. You sign the PDF form, you're done. The schedule's where you make your decisions and your negotiations. Part 1 are your termination provisions. And one thing we're seeing more and more as a result of Dodd-Frank is specific termination provisions dealing with payoff, transfer, principal reduction, etc. of the related loans to ensure that the swap is in fact a hedge. If you have a swap and nothing to hedge, then you no longer have a hedge. And you may lose the qualification under Dodd-Frank in addition to the exceptions for clearing and for posting of margin. You'll also have tax representations. This is where you make your specific tax representations depending on jurisdiction. Obviously, if you have two parties in the United States, you're going to be representing that you're both U.S. persons and that you're not subject to U.S. withholding. This is important because the general rule under the master agreement is that you gross up any payments for withholding taxes. And if you do not want to do that, then you need to make that clear in the schedule. So you'll make no deduction of withholding representations here. Part 3 is your CPs. It's the agreement to deliver documents, whether that be opinions or otherwise. If, for example, you have a third-party swap provider, a swap provider that's not involved in the underlying transaction, such as you bid out your swap and let's say you pick SMBC even though your lender is a U.S. company, SMBC will generally provide opinions to cover that, both for their underlying swap transaction and for their guarantee that they'll issue out of Japan. They'll do that as a matter of course. If, on the other hand, you represent the borrower and your swap provider is also the lender or is an affiliate of the lender, then generally you won't get an opinion, although that may vary depending on how important you think it is to receive an opinion. On the other hand, they may require the borrower's counsel to issue a swap opinion. It seems to be becoming a little bit more common, although I wouldn't say it's standard by any means. Moving on into part 4, that's obviously payment information, addresses for notices, etc. And then finally, in part 5 is just a big miscellaneous. You'll cover, for example, you'll modify the transfer provision in the master agreement to allow transfers to a transferee lender of the loan. That's usually covered there. You'll also see some Dodd-Frank representations there to make sure that the borrower or party B is an eligible contract participant. If you have an EU bank that's involved in the transaction, you'll see EU bail-in provisions. You'll see EMIR, which is the European Market Infrastructure Regulation, and they'll require you to make certain representations under EMIR. It's helpful if you have time to read EMIR so that you can properly make these representations because they're going to try to put the impetus on you to do so. Even though you as a U.S. person or your client as a U.S. person won't be subject to EMIR, they are, and they're going to want to make sure that they're complying with it. And as I said before, you also may modify the gross up provisions, particularly the definition of indemnifiable tax in the back of the master to eliminate indemnifying a foreign counterparty for any U.S. withholding taxes. And then again, they may add 6 and 7 depending. Again, if it's an EU bank, you'll see a section 6 covering EMIR. And under EMIR, there'll be a confidentiality waiver. And then they'll also ask you to designate whether you're a financial counterparty or a non-financial counterparty, and then there'll be some more detail on that. So let's move on now to the confirmation. So we have the master. That's a complete form document. You sign that. You have the schedule where you make your general changes to the master and you make some designation. The confirmation is really the nitty-gritty of the deal. This will give all of your financial terms. So you'll have the notional amount listed in here, and whether it's a fixed notional amount or whether it's an amortizing notional amount, that'll be dealt with in the confirmation. This is where they'll set forth the fixed and floating rates. They'll set out the interest rate accrual periods, the business day and business day convention, your payment dates, the expected termination date, payment instructions, etc. will all be put here. And again, I said this before, but it's very critical that you review the confirmation to make sure that those terms align with what's in the loan documents. If you're going to hedge your loan, you've got to make sure that you're hedging your loan. the payment dates align, etc. And this is also where the onus will be placed on your swap provider to meet the underlying ratings requirements in the credit agreement. So if there's a downgrade provision in the loan agreement that says you have to replace the swap or cap, this is where those provisions need to go, and they should pretty much mirror what's in your loan agreement. You don't want an obligation on the borrower that's not mirrored out to the swap or cap provider. And that will include replacing for a downgrade, posting collateral, or providing a guarantee from an entity that has the credit rating. All of that should be put in here. Something else to consider here is the timing of payments. I don't see it as often anymore because I think most of these are now assigned directly over to the lender in the transaction. So payments are made directly to the lender. But that may not be the case. And it also depends on how tight cash flows may be in the deal. But sometimes it's worth having the payment dates under the swap or cap made one business day ahead of the payment dates under the loan agreement. This allows you to receive those funds in and then transfer them back out to the lender if necessary. Again, probably not critical, probably not even necessary, but it's something to consider. Okay. So we've gone through sort of the basics. We've gone through the documentation. I don't see a lot of questions so far. If you have any, please speak up on what we've covered thus far. I'm happy to answer them now. I'm also happy to answer them at the end. But I think now let's move on to our basic regulatory regime in Dodd-Frank. But before I go on to Dodd-Frank, I want to again mention EMIR, or EMIR, which is the European Market Infrastructure Regulation. Dodd-Frank came in July 2010. EMIR came in July 2012. And it covers over-the-counter derivatives transactions done in the EU. And this is important because you'll probably do a number of transactions in which the swap provider or the cap provider is an EU financial institution. And they'll want basic EMIR representations and other waivers, such as bail-in under the EU regulations, to be put into your documentation. But under Dodd-Frank, there's three things that I want to highlight today. One is that the borrower under your underlying loan transaction, or party B to the swap, the counterparty, and any guarantors that are guaranteeing the obligations under the swap must be, quote, eligible contract participants, or ECPs. Two, the transaction will need to fit within an exception for clearing if you don't want it cleared. And party B must make an election to do so, so it's not cleared. If party B doesn't make that election, then it is required to be cleared. And three, party B must qualify for an end-user exception if they don't want to post margin. As I mentioned earlier, Dodd-Frank was passed in July 2010, and the U.S. was the first mover. And there's still discrepancies among jurisdictions. But most of the regulations that we've been expecting have come through. We have a good feel for, at least in this area, we have a good feel for what's required and what's not required. The EU regulations were published in July 2012, 2 years after Dodd-Frank, as I said before. And then you can also find EU bail-in provisions, and I've listed here on the slide so that you can look them up to compare to what's being offered to you. But if you're entering into a swap with a European bank, EU legislation requires them to require you to bail in to their ability to write down the obligations of these financial institutions in the case of a bank failure or reorganization. And they require you to bail into them. So the Loan Syndication and Trading Association's website contains standard EU bail-in provisions. And then ISDA also comments on the valuation of derivatives in a bail-in if you really want to nerd out on that. That's kind of interesting to read. So the three areas we wanted to cover, let's start with eligible contract participants. So Title VII of Dodd-Frank amended subsection 2E of the Commodity Exchange Act to make it unlawful for a person who is not an eligible contract participant to enter into a swap other than on or subject to the rules of a designated contract market, basically a clearinghouse. And the CFTC can bring enforcement actions, and other agencies can bring enforcement actions if that's not the case. And to add to the pain, the transaction itself would not be enforceable if it's not with a ECP. This is why the banks work very hard to make sure that the parties that are purchasing their caps and entering into their swaps are in fact ECPs. In addition, all swap guarantors must be ECPs. And this was reiterated in a CFTC letter. And it's important then to make sure that the language under the guarantees that are entered into in connection with the transaction have certain provisions to prevent a guarantor accidentally guaranteeing swap obligations if it's not able to meet the ECP requirements. And you'll see this in most documentation. So the definition of ECP is found under subsection 1A18 of the CEA. And the term includes one, and I think this is the most important for most of us sitting at the table today, are entities with a net worth of at least $1 million that are hedging commercial risk. Now again, that's net worth, that's not assets. That's entities with a net worth of at least $1 million that are hedging commercial risk. Also, you have corporations, et cetera, that have total assets exceeding $10 million, along with a few other obligations. And finally, and again, this is important in respect of if you're doing transactions for high net worth individuals or new funds where individuals are guaranteeing obligations, then that includes an individual who has amounts invested on a discretionary basis, the aggregate of which is in excess of $10 million or $5 million, and who is entering into the agreement, contract, or transaction in order to manage the risk associated with the asset owned or liability incurred. In other words, to hedge. So that's amounts invested on a discretionary basis of $5 million in hedging. Again, that's not net worth. And I said earlier that there's certain provisions that you'll come across because of the concern of making sure that guarantors are ECPs. And ISDA has created two separate provisions, and you'll often see these together in the documentation. There's keep well provisions, which provides that the guarantors who are ECPs will make sure that the other guarantors can qualify by providing financial support so that they qualify as ECPs. This is less important, for example, in a basic non-recourse real estate transaction. Probably much more important when you start looking at a swap that supports a credit agreement where you'll have subsidiaries guarantee the obligations of the parent company under the loan documents and then the swap, particularly if the the lender is also the swap provider, because then they'll incorporate all of the provisions into the loan documents that say you are guaranteeing the swap obligations. In addition, they've published a series of provisions that specifically exclude any guarantor who doesn't qualify as an ECP. And the language for these can be found at that link that I've included in the slide. So we've talked about ECPs, eligible contract participants. That allows the borrower or the party B to enter into the transaction. The next stage is to address clearing requirements. So Dodd-Frank amended the CEA to require that all swaps be cleared through a regulated clearinghouse if the CFTC determined that that type of swap should be cleared. The long story short of this is that the CFTC has decided that the rule generally applies to interest rate swaps. So generally applies to interest rate swaps. Next question is, do we have an exception? And funny enough, we do. So for our purposes, the pertinent exception applies to a party that is a non-financial institution, the end user exception. That definition is a little bit more broad than it sounds, and I'll go through it a little bit later. But if the non-financial institution is entering into the transaction for hedging or risk management purposes, if the end user elects not to be subject to clearing requirements, then it's not cleared. And again, this election must be documented and reported. This is one of those areas that if you filled out the Dodd-Frank documentation to enter into one of these deals, you'll see 22, 23 page up to 41, 42 page questionnaires that you have to fill out. It is very helpful if the lawyer fills that out and then asks all those questions of the client, if the client is not that familiar with swaps and derivatives, to make sure that you walk the client through it. If you've got somebody on the client that's very familiar with this, then probably don't need to spend the legal fees doing it for them, but it's something to consider. I'll also note that if the end user is an SEC reporting company, then it must get board approval for the election not to clear the swap. Let me say that again. If you've got an SEC reporting company that's entering into a transaction and they don't swap clear, then you have to get board approval to make that election. Again, not as important in a sort of non-recourse real estate space, but much more important on a revolving credit facility or something like that. Okay, finally, we've talked about ECPs, we've talked about clearing. Now let's talk about margin. In August, all of these organizations published their uncleared swap margin rules and the non-financial end user exemption. So we have the prudential regulators, the CFTC and the SEC. SEC proposed similar rules. And they generally exempt the following institutions and transactions from the initial and variation, so initial margin and margin going forward as pricing changes, requirements for non-cleared swaps. Again, non-financial end users that are using a swap to hedge or mitigate commercial risk. Again, you've noticed that phrase has come up both in qualification as the ECP and under the clearing requirement and under the margin requirements. In addition, small banks, savings associations, farm credit system institutions, and credit unions with total assets of $10 billion or less that are using a swap to hedge or mitigate commercial risk. And then probably less relevant to this crowd, captive finance companies that are used to swap or hedge, mitigate commercial risk. So I think most of us will come across non-financial end users that are using a swap to hedge or mitigate commercial risk. If you're working with community banks, then you also have the small bank exception for assets less than $10 billion. Okay, moving on, another slide. And while I covered sort of the definitions at the beginning of hedging, there's an actual list of what they mean by hedging under Dodd-Frank. If you're an accountant, you can look at the CEA rules, FASBS number 133, etc. But you can also simply look at this third bullet point. And the question is it economically appropriate for the reduction of risks in the conduct and management of a commercial enterprise where the risks arise in the ordinary course of business from a fluctuation in interest, currency, or foreign exchange rate exposure arising from a person's assets or liabilities? And again, this applies if you have an SPE, their business is owning a office building or they're owning a hotel, and that SPE has a financing arrangement that's at a floating rate. You're clearly hedging that risk. I'll note, however, that the final definition specifically excludes a swap position that is held for the purpose that is in the nature of speculation, investing, or trading. Now, that's the end of sort of the overall discussion. I said earlier that I'd like to cover some thoughts on where we might be headed with Dodd-Frank, and I'm certainly not the only one that speculated over the last few days. There's plenty of commentary out there. We're working on an article here to go through it, but as information comes in, it changes on a daily basis. And the problem is, your views and speculation may change as additional information comes in. So let me just say what we know so far with Dodd-Frank. Trump did promise during his campaign to quote, get rid of Dodd-Frank. We know that. He also appointed Paul Atkins, former SEC Commissioner under George W. Bush, as his point person for review of the financial agencies. And Atkins has in the past referred to Dodd-Frank rather bluntly as a calamity. If you go to the transition team's website, that team has reiterated his calls to dismantle Dodd-Frank as of last Thursday via a post on, and I'll give you the link. I don't have it on the slide. It's www.greatagain.gov/policy/financial-services. And on that page, the team calls Dodd-Frank a sprawling and complex piece of regulation, and it does highlight the issue of bailing out financial firms which are deemed too big to fail. It also goes on to wish that they wish to replace Dodd-Frank with new policies that encourage economic growth and job creation. I think it's important to note that they don't address derivatives on that page. Just yesterday, actually I think it was the day before yesterday, the current chairman of the CFTC, Timothy Massad, stated that the consensus has formed that many reforms such as central clearing have proven beneficial to the markets. He also stated that the CFTC will shortly release the results of its stress test it conducted on 5 clearinghouses, and that will show that those clearinghouses would perform under extreme but plausible scenarios. Again, quote, extreme but plausible. This seems to be signaling to the incoming administration and in hopes of paving the way to keeping central clearing. I personally think, and take that with a huge grain of salt, is that it's not going to be easy to dismantle the basic ECP requirements and the clearing and margin provisions of Dodd-Frank, because the derivatives market has worked so hard to sort of put those together and is still working hard to make sure it's coordinated. That includes ISDA and the EU. And I think it's at least probable that they do in fact work. That said, as I think anyone who's dealt with the 30 to 40 page Dodd-Frank questionnaires that I mentioned earlier could attest, it definitely could use a paperwork reduction act. And we may see some simplification of approach, but that's highly speculative. 2, I think the Volcker rule is going to be a bigger target, and that's going to be severely cut back or eliminated over time. And I say that because the timing on Dodd-Frank isn't clear. Representative Hensarling has noted that incoming congressional Republicans in the Trump administration have prioritized repealing the Affordable Care Act and moving forward with tax reform over that priority. And so we'll have to wait and see. Now, that concludes my overview. I think we do have a few moments for questions if anybody wants to ask anything that I haven't covered or provide additional color on anything that I have. I'll give you a few moments to message in if you do have any questions. All right. I think that's all we have, and I think we can conclude. Crystal?
Thanks, Mark. That was fantastic. I just wanted to remind everybody, oh, it looks like we might have one that came in. Can you see that, Mark?
Okay, Gil Parker has asked, time permitting, please address the qualifications that should be added to an enforceability opinion regarding a swap agreement supporting commercial real estate loan. I think, by and large, you take out a general carve-out for Dodd-Frank. Again, the question is whether it's enforceable under Dodd-Frank. The relevant provision under Dodd-Frank is qualification as an ECP. I think you could argue that a legal opinion generally carves out factual information, and so I think you could argue that any opinion would carve that out anyway, but I think it's wise to generally carve out Dodd-Frank. There's several different ways of doing that. We have one way, some other firms have another. There's another question regarding commenting on provisions relating to negative LIBOR rates after Brexit. All the documentation covers negative LIBOR. I will say that many lenders will specifically exclude any LIBOR rate under 0 in calculation of their interest rate. If you are entering into a swap, you can usually eliminate that provision, and everybody's, and usually that is satisfactory. And that's all we have in terms of questions, unless there's anything else to add.
I don't see anything else. So Thank you,
I think
Mark.
that's it.
It was really great to have the chance to listen to you today. I think I can speak on behalf of everybody else when I say that. I just wanted to remind everybody before I sign off that in the next few days, I will work to distribute a copy of the presentation, a recording of the webinar, as well as Mark's contact details. Please do not hesitate to reach out to him directly if you have any further questions or anything comes up in the meantime. I also will check back with Mark to get that web address that you mentioned, and I will include that in the follow-up email, if that's okay.
That sounds good. Thank you all for listening in.
Yeah, great. Thank you. Have a great day, everybody. Bye-bye.
Thank you.